So good evening, everyone. I'm Rashida Hilliard, the housing chair, and I'm here with Richard,
Richard Perez.
who's also on the committee. Um, Currently, we are waiting for other possible like committee members to join. Well, actually, we're not waiting for them. What I'm saying is, if you hear bell rings, if you hear the bell ring, I will most likely get up to open the door. But we can always get started. So it's 6:33. Um, and basically we can get started in roughly 2 minutes after the introduction. Obviously I'm gonna skip over the roll call because we don't have a quorum just yet. Um, but at least I've introduced myself. I know you have spoken to us, I think it was last year in November, about tenants' rights and responsibilities. So we thought it would be a good idea for you to come back to talk about the good cause of eviction. And I'll say that we tend to follow the Roberts rules rule of order. If there are a lot of people who would like to speak, we ask that each person speaks one time so that and also make sure that whatever you say that it counts. Um, I'm just saying this now, but of course people can probably speak more than once in this case. If you're on Zoom and you would like to raise your hand, um, you can, if you're on your computer, I'm sure you'll see the at the bottom of the screen, it'll have like where it says raised hand and things like that. You can use that. If you're on your phone, I would like to say, I think it's *6, maybe to raise hand and *9 to mute, or the other way around. So is that correct?
I'll double check.
Thank you. It'll be double checked, but with that being said, as I mentioned, so that's sort of the introduction. As I mentioned, we'll skip over the roll call for now. But I'm Rashida anyway, and Richard is here. And I will also skip over the approval for committee minutes because we cannot approve the minutes without a quorum. Um, but as I mentioned, our main discussion for today will be with HPD. And is it Robel Techley?
Correct.
Okay.
Tetlab, yes.
Techley. Thank you. So our main discussion will be with HPD about the good cause eviction. And as I understand it, the good cause eviction is a law that went into effect on April 20th, 2024, and it provides tenants of unregulated, aka market rate homes, new protections. So that's like where I'm going to stop, and I'm going to turn it over to you after your presentation. Um, it will be a Q&A, and then we'll move from there. So thank you for coming once again. Thank you for coming back.
It's a pleasure to be here. And thank you for having us because information and resources the city has is no good if the community doesn't know about it. So that's the reason why we do this work and be a pleasure to come back and over again as much as you need us. So thank you for having us. Um, that said, let me just share my slides and we'll get going. All right. Um, okay. So first, let me just again say what an honor it is to be invited again. We had a very productive um, class, if you will, an introduction to the various tenant rights in the city. We covered, I think, last time was the stabilized group of apartments, and now we have one more tool in our toolbox to help tenants in New York City. Um, it's people may have wished one way or another type of this law, but we're grateful to have it as it is, and hopefully even stronger versions of it will come. But here's the agenda first. We're going to be talking about what it is, uh, and we'll talk about how one finds out if one is covered by the good cause eviction protection law and what landlords are required to do and how one may use the good cause eviction law to challenge rent increases, and then we'll do the Q&A. But meanwhile, I do want to introduce my colleague, Maria Donato, who's joining us here. Between the two of us, we'll try to encircle and answer all the questions with the knowledge we have. And feel free, if anybody wants to chat, if there's a chat feature, also type up, because you might get your answer quicker. While I present, Maria might be able to answer your question. So that said, all right, so the good cause eviction law, as you said, Rashida, came into effect in April of 2004, and it established a list of allowable good cause reasons that a tenant can be evicted or refused a renewal of lease or otherwise be removed from an apartment. Now, it applies, excuse me, tenants can use the good cause eviction law as a defense in housing courts if a covered tenancy is terminated or stopped without a good cause or good reason, if you will. Unlike previous rent stabilization law, however, which is enforced concurrently by the courts and DHCR, the New York State's Department of Homes and Community Renewal, the court system has now an exclusive enforcement powers over good cause eviction. And it applies to tenants of some unregulated units that, AKA, as you said, Rashida, what used to be known as market rate apartments, some types of buildings, units, and landlords that are also exempted. Now, it requires landlords to notify tenants whether their unit is subject to good cause eviction regulations or not, when offering or renewing lease and when sending certain notices as well. It allows tenants to challenge reasonable rent increases if they are sued for non-payment of rent in the housing court. And it also limits the allowable reasons landlord can evict tenants. There are still some good reasons landlord can evict tenants, but it limits them. Now, let's talk about what are still good reasons for or allowable reasons for a landlord to evict, though. Non-payment of rent cannot be protected because of the good cause reasons. If you don't pay your rent, you must, a landlord can try to evict you. Now, there's exception to that. If, however, the increase a landlord, let's say, has brought up is unreasonable increase, that meaning it's over 10% for that year or 5% plus inflation, which currently is 8.79 for New York City, then you can challenge it. Otherwise, non-payment is not challengeable. Violating lease or other tenancy obligations are also not a protection. If you also cause nuisance or damage a unit, or if a vacate order has been given, or if you've been using it for illegal use, or if you've failed to provide access to the landlord to make necessary repairs or to show the unit, or if the tenant fails to agree reasonable changes to the lease, and if proper written notice had been provided, then you won't get protection either. Now, if the landlord seeks to use the unit for their own primary residence, also you may not be given protection. However, the landlord must provide a clear and compelling evidence in court if they're claiming one of those reasons, like saying that I am going to use it for myself or for a family member. Or if the landlord also claims they wish to demolish it, they can do so as well. You can still be evicted for it. But again, they do have to demonstrate in court that in good faith they're trying to indeed do those reasons that they claimed. Now, this wouldn't be applicable for units that are occupied by tenants with disability or people who are over 65. However, they have, but people with disabilities or seniors have a bit more protection. They cannot be evicted. Now, one must not also have suitable units in the building to be able to not to be able to transfer someone into those suitable units if they're going to evict you. Again, landlord can seek in good faith to withdraw the unit from the market as well. Some people call it warehousing, if you will. And they can, unfortunately, but they do have to show that they are not indeed going to keep it in the market. They're not just evicting you and trying to bring somebody else, but they actually are trying to take it off the market entirely. I know I have said a lot here. Fortunately, they have had too many exceptions that you couldn't be protected from, so I had to list them out. Hopefully they're clearer, but happy to clarify when we have the Q&A later. Now, now let's talk about what it isn't. The good cause eviction law, it's not a universal rent stabilization law. Some may think, and landlords have tried to talk about it as a form of another way of doing rent control or rent stabilization. But there are key differences. You may notice here we have the rent stabilization versus the good cause. The rent stabilized apartments, you might remember, are governed by the Rent Guidelines Board, and the increase is determined by them. It is also governed by the Department of Housing and Community Renewal, and succession rights for family members living in the unit is also enforced. And more importantly, when we talk about DHCR governing it, we're talking about DHCR being able to issue rent reduction orders. In this case, in the good cause case, it doesn't have any of those powers. The annual allowable rent increase is determined by a formula of inflation, meaning like 5% plus whatever that inflation rate was for that year, and if it's under 10%. If it's over 10%, however, it's capped at 10%. That's just the law, sort of permanent law, if you will, for now. It doesn't go to Rent Guidelines Board at all. Meanwhile, the courts, as I mentioned earlier, have the exclusive rights to enforce the law. And the way it is enforced is as a defense, unfortunately, in housing courts from people being evicted. There are no succession rights for those group of apartments, and protections depend on many different factors, which I just discussed. And there is no rent reduction order for decreased services, unlike rent stabilized apartments. You might remember if a landlord is not doing the repair they need, or they're giving you the service that you deserve, you could literally go to the Office of Rent Administration or write them, apply in their forms, and you could get rent reduction order. But you can't do that for good cause. You could only use it in court once you've been sued for non-payment or something like that. We'll talk a little more about it in detail. Now, first, just let me take an opportunity to just use the QR code in case we have some tenants or anybody else who's curious about how they find out if they are if their apartment is rent stabilized. While we're at it, just take advantage. If anybody wants to QR scan this, we'll be happy to bring it back later as well. But you can find out by going to the Department of Homes and Community Renewal, Division of Homes and Community Renewal website as well. Now,
Actually, Matt,
yes,
sorry, I just want to quickly ask, since this is being recorded, will we be able to receive the slide deck so that people who aren't here can scan the QR code for future reference?
absolutely. We'll be happy to send you the website as well. It just takes you to our website, so we can do
Oh, no problem. Thank you.
Now let's talk about how one finds out about good cause and whether if one is covered by the law in the first place. And let's talk about the types of homes that are not covered by good cause. I wish I was talking about the positive, the type of homes that are covered, but it's easier to talk about the ones that are not covered. So let's talk about that or units that are not covered. So first, public housing, such as NYCHA, or already rent regulated apartments and income restricted units are not covered. Buildings that are owned by small landlords, you know, 2-3 family houses, and if that's all they own, are not covered. Or owner occupied buildings with 10 or fewer units, those are not covered either. Unless the totality of what that landlord owns end up being over, being 11 statewide, by the way. Co-ops and condos are not covered either. Buildings that were built after 2009 or later are not covered either. For now, at least. They would be covered 30 years from now, unfortunately. Housing tied to employment, meaning, a lot of hospitals, supers unit, or a lot of hospitals, for example, have apartments for their tenants or for their employees. Those aren't covered either. Units where the rent is more than 245% of fair market rate. You might call this a luxury apartment. Those are not covered. Luxury apartments are not covered. Units that are being sublet if the primary tenant wants to return, those aren't covered. And of course, hotels, care or assisted living facilities, and dorms are also not covered. All right. Now, you've seen a lot of what is not covered, and I just want to say a little bit more detail about the small landlord exemption. You may not be covered by good cause eviction protection if your building is owned by small landlord who owns fewer than 11 apartments statewide. Just want to clarify that. Statewide, not just in New York City, but across the whole state. Could be Buffalo, Rochester, and New York City. Like if somebody has, say, 6 here, 4 in Buffalo, and 1 in Rochester, it means any of those apartments would be covered, since the totality of what that landlord, and by the way, I'm talking about units, not necessarily buildings here. The totality of those units that landlord owns are over 10, then you would be covered. If they had been less than that, it would be not covered by the law, meaning you would not enjoy the protection of the good cause eviction law. Good cause only applies to buildings with 11 or more units, or buildings with fewer than 11 units if they're owned by a landlord who owns 11 or more units in total statewide. Now, a unit is just an individual apartment, and a building refers to the external structure overall, containing multiple distinct units. This small landlord exemption, hopefully, I have 2 examples here. Hopefully they make sense to you. Say if a landlord owns 3 buildings each with 3 units, it would own 9 units in total. This portfolio would not be covered by good cause eviction protection. Why? Because the total number of units are under 10. In the second example, if a landlord owns a building with 6 units and the building with 8 units would own 14 units in total, this portfolio would be covered by good cause eviction protection because they would exceed the 10 units limit, right? Since they've become 14. So that's the total calculation. And of course, remember, this is statewide, not just in New York City. Now, how do you actually know if your apartment is eligible for good cause? Well, our colleagues at Just Fix It built this wonderful website called goodcausenyc.org, and you can QR scan this as well and try to find out. And so if you go to their website, you could basically see the number of units any buildings has, and of course, they have a way of tracking how many units the landlord owns statewide. It doesn't mean it's perfect 100%, but it's a great start, and they do a wonderful job of letting us know how many units a landlord particularly owns, or how many. Just they track the portfolio of apartments, and we found it very useful. It may be useful for tenants to follow through. The website is goodcausenyc.org, and it's built by Who Owns What. That has built the JustFix.org. Same again. Just wanted to give you what it looks like when you go look up at the Who Owns What tool. You can see in red the number of units any particular building that are owned by various landlords are there, and you can track if your landlord particularly exceeds the 10 units statewide requirement by using this tool. Now, there are some requirements here for what landlords are supposed to do in terms of obligation. You know, especially in its initial years. Eventually, people will get a hang of it and will know their rights. Hopefully, with these types of outreach we're doing. But initially, the tenants will not know, so it's obliged landlords into doing some necessary work. And among this is like the landlords are required to give tenants written notice, as you see here pictured, explaining whether or not good cause eviction protections apply to them. This must be included with any new leases they give tenants, or any renewal, or any notice of non-renewal as well. And of course, notices of rent increases of 5% or more, or any 14-day rent demands, and notices of petition in eviction proceedings. You can also, as a tenant, request this notice if you do not receive it from your landlord. But this is a requirement for the landlords to provide with any documents they have. And now they all should know if as you see, a landlord that owns 11 units, kind of is in the real estate business. And so landlords know now how it's supposed to be done. So if they don't, do follow up, please. Now, how can one use the good cause eviction to challenge a rent increase? It has two purposes, essentially, the good cause law. It's to prevent unreasonable eviction and to prevent unreasonable increase. Those are the two purposes. Now, in terms of the rent increase, uh, it is a tool for you to refuse to pay the increase if it's unreasonable by not paying and forcing the landlord to take you to court and for you to use that law to defend against the landlord's claim. So it is considered unreasonable as I mentioned earlier if it is higher than the local rent standard. The local rent standard again is defined as 5% plus inflation or under 10%. It's a cap. 10% is the cap, but anything below that 5% plus inflation is the law, whichever is lower, by the way. Um, as of April 2025, inflation was 3.79%, meaning the current rent limit for a reasonable increase is 8.79%. They can go as high as that. So they can't go above that, but they can go up to 8.79% for those apartments that are covered by good cause law. You can find the annual local rent standard on HPD's Good Cause Eviction info page, but it is also published everywhere in terms of any tenant organizing or tenant organization as well. But HPD's is the hub, and we encourage you to check that. Notice that this amount changes annually. So depending on your rent was increased, the definition of an unreasonable rent increase may be different. So do please seek a legal help to review documents showing a rent increase. And of course, we encourage people to use their, neighborhood community-based organizations in terms of legal services. And if you believe that your landlord has increased your rent by an unreasonable amount, a court will have to decide whether the increase is reasonable. Now, in terms of the unreasonableness of the rent increase and eviction, if one is facing eviction due to the non-payment of rent, mind you, we talked about how this is a defense against an unreasonable increase and following that unreasonable eviction. If you believe you received an unreasonable rent increase, you can use the good cause eviction law as a defense. Keep on saying it over and over again. And however, we do encourage you to continue paying your previous rent while the eviction case plays out. This isn't you increased it unreasonably, therefore I'm not paying at all argument or defense. It is, I am going to pay what I have been reasonably paying. Now you have become unreasonable. I will not be paying the unreasonable amount is the defense here. If your landlord refuses to collect this rent or you are withholding rent, do save it on one bank account. May have heard something called escrow. And be prepared to pay back the rent if you lose your case. It is possible to lose the case because sometimes a lot of this is discretion on the courts and judges as well. So the good cause eviction law applies to eviction cases where the landlord first filed documents after April 2024. Anything that was filed before that, hopefully by now it's been adjudicated. But in case you're not, there may be cases that aren't adjudicated almost 2 years into this. It wouldn't apply if your case was filed before April 2024. It is for anything after that it applies. Now, it is important to seek legal assistance if you believe your landlord is violating the law, and recommend you go to neighborhood legal service providers, a lot of good organizations in the city, including the Bronx. In terms of eviction threats, if your landlord refuses to renew your lease, or tells you that you must leave without good cause, or tries to evict you without a judgment of possession and warrant of eviction from court, meaning the court didn't say so, we encourage you to stay in your home. Don't leave. Don't just leave because the landlord says, I'm going to evict you. Landlord does not evict. Landlord files for eviction, and the court or judge decides to evict, and that is enforced through marshals. Unless a marshal shows up, uh, you have not been evicted. Any paper that says otherwise is not an eviction, unless it's a court document. Landlord document is not a court document, just to clarify. Your landlord must also give you at least 30 to 90 days notice, depending on the amount of time that you have been leasing in that apartment. If you were just there for less than a year or just a year, they have to give you a month. If you were there under 2 years, but over a year, they have to give you 2 months. If you were there over 2 years, but under 3 years, they have to give you 90 days or 3 months. And anything above longer than that, also 3 months. That's the max. But they do have to give you a longer notice depending on your stay as well. Now, as a reminder, under good cause eviction, your landlord can only evict you for the following reasons. We just reiterate again, I know we've gone through them already, but non-payment of rent, violating a term of the lease, or if you causing nuisance or illegal activity, if you fail to sign a lease renewal, or if you fail to provide reasonable access to your apartment for repairs, or for your landlord to show the apartment for rent or sale, or if landlord is taking over the apartment for personal use. Now, mind you, remember the exceptions here is I am using it for personal use does not apply if the home is occupied by a tenant who is over 65 or has a disability, or both sometimes. So there's that exception. But overall, landlords can say, I'm going to take it for personal use, and you would not be protected. Or if landlord is taking the apartment off the market, or if they're demolishing the building overall. In terms of eviction proceedings, I know a lot of people may not know what courts are like, and it can be a scary place. So thought we'd just say a little bit about that. There are multiple steps in this in terms of eviction proceedings. Hopefully nobody has to be in that situation. But initial is the predicate notice, meaning landlord sends letter or legal notice to the tenant, notifying them of the rent they own, or another issue. They may also be called 10-day notice, or rent demand, or notice to quit, notice to cure, notice of termination, etc. There are multiple names that this goes by, but it's the predicate, meaning the pretext, if you will, for eviction. And this often comes from a landlord's lawyer. Now, next step is notice of petition. And a petition, this is a court paper notifying the tenant that the landlord has filed case against them, and it gives you instructions for, as a tenant, which may include a court date or instruction on how to answer the petition. And the third is the eviction notice itself. Notice that the eviction is being scheduled by the marshal. The notice has a number that tenants can call to find out if or when the eviction is scheduled. If you receive any court documents, we advise that you call the tenant helpline and request a legal referral if you cannot afford an attorney by yourself. Right to counsel. You may have heard about the right to counsel uh, service. New York City provides that, and we advise that people contact the tenant helpline. Now, in terms of generally what the eviction paper looks like is I realize this is not the best of pictures, but this is just to give an idea. It's what it looks like, and it's what the courts will send to you, not the landlord, the court. Uh, but here are the three separate papers: rent demand at the beginning, notice of petition second, and notice of eviction last. And that's this is multiple prongs step. And what I would say here is if people hear the word eviction initially, they should not panic. There is still time. The court process is a bit lengthy, and there may be a way to, uh, whether it is rent arrears, rental assistance, or any other one-shot deal, or any other assistance people might need. The city also has various services, so we advise that people don't panic. As bad as it may sound, it takes it takes a while for eviction processes to go through completely through the court process. So have people not be panicking. As scary as it is, I do not want to underplay how scary it can be, but there is a little time still to fix things. This is also just to give you an idea what holdover eviction papers look like. Holdover is basically the violation of lease type of eviction. So this is what the document looks like. And here, one thing I want to say about housing court is your landlord can only legally evict you after obtaining a judgment of possession and warrant of eviction issued by a housing court judge, meaning a court's decision. I know it's multiple words there, very legalese, but it just means the court's decision. And of course, only a New York City marshal can legally remove you from your home pursuant to a warrant of eviction, meaning, based on the court's decision. If your landlord tries to formally evict you in housing court, you can use good cause eviction as a defense if it applies to you. Again, make sure that it applies to you. However, not all apartments, as we've talked about at least twice, are covered. So do make sure that your apartment is covered. Please also seek legal advice or representation to help you best defend yourself through right to counsel and other resources. And just to summarize, if you qualify for good cause eviction, it can be used as a defense to unreasonable rent increase or denial of lease or renewal in housing courts. It does not apply to all apartments, and it does not provide the same protection as rent stabilization laws. And do seek legal advice if you're at risk of eviction or you face an unreasonable rent increase or a denied lease renewal. Now, that brings me to the end of presentation. Hopefully it's been useful and clear, but if it hasn't been clear, we'll try to clarify things in the question and answer session. So I open it up. Thank you.
First of all, thank you for that presentation. I know I see Valerie's hand, but I just wanted to first say thank you. Just as last year, you've provided us with a lot of information to share with our community, and we thank you again this year. And hopefully, this will be a trend that as we learn more about different laws or what have you, or different resources that you can share with us in our community. So thank you, and I'll turn it over to Valerie.
Thank you very much. That was really great. I'm here because I read that a lot of homelessness is caused by evictions. Um, and what recourse do people have when they can't pay the rent? I'm especially shocked to learn that public housing is not, you can't use good cause eviction, right? Public housing. And that would be the very people that would need it some protection most. I guess my question, and this may not be your topic today, but what do people do when they're evicted besides become homeless?
Well, it's an excellent question, and I appreciate the care and the concern. The case of public housing is a bit different, and there's actually, I would say that people in public housing have a whole lot more protection than anybody else. Starting from how low the rent is. I know it's outside of my topic, but just based on my experience, the rent is pretty low, very low, and the process there is much more kinder, if you will, than non-public housing apartments. The people that have been hurt and that still have no recourse whatsoever are people in the market rate, because they're sort of, other than that lease, they're at will tenants, if you will.
Mhm.
And that's who this law is supposed to help. But we do know that people fall in hard times, and people are sometimes unable to pay their rent. And you may have heard me talk about rent arrears and one-shot deal, and our colleagues at the Department of Social Services are excellent at this, and they contract out with various organizations throughout the city to do the work of what is called home base. Be happy to drop down and chat if there's a chat future about home base. But the home base services are throughout the city, and their job is to help people prevent eviction by giving them access to rent arrears. So they could either go to home base centers and apply there, or they could go to an HRA center, or even way more easier than that is use what is an app called Access HRA, the Department of Human Resource Administration, which is under the Department of Social Services, that has this tool where people can apply for rent arrears for one-shot deal, basically. And the one-shot deal, despite what it says, is one-shot deal as many times as you need it. So there's that. The city is, I would say, pretty generous in terms of trying to keep people in their homes as long as they seek it. That's the hard part. A lot of people may not seek, and it can be, I will admittedly be saying that the process can be a bit bureaucratic and frustrating sometimes, but if people stay at it and they can show to even courts that they are in the application or in the processing process with Department of Social Services, which, by the way, have also locations and offices in the courts to help people apply for those services, then people may have an easier chance of staying in their homes. There are various resources in short.
Thank you. I just wanted to say we don't have a chat feature, unfortunately. So I guess if you had, let's say, a website and you wanted to say it out, at least we're being recorded. So
yeah, home base. Just search home base or Access HRA on your website, any in Google, and it will pop up. Access HRA is a great app or website, and people can apply for one-shot deal or any other assistance. This is, by the way, where people access any kind of assistance, including SNAP or any other assistance that they may need.
Yeah, I have another question.
Yeah. Do you mind going back to the slide where you talk about reasonable or reasons why people can be evicted?
Mhm.
Keep going, keep going, keep going. Right here.
Yeah.
So third bullet down for reasons, it says nuisance or illegal activity. I mean, the word nuisance for me just like feels, what is that, you know? Because some people have children that are, you know, running around all day. Is that a nuisance? Could that be, you know, a reason to evict somebody? Some people have, you know, support animals as well. What defines a nuisance, right? Shouldn't it just be illegal activity? I'm just confused by that. Like, what are some examples of nuisances that like a landlord could use against a tenant, you know, as a reason for eviction?
You know, this it's a great question, and it's very vague, and I probably should get back to you with more details. But in short, it just means really disturbing the building in such unreasonable way, like music here and there, or a child being rowdy, or a dog barking is not. That's that's not unreasonable. It's part of nature and part of uh, life. But Maria, you have something to add? Go ahead.
Yeah, I was, excuse me, I just wanted to add to what you said, Robel, that yeah, it's more related to disruptive behavior, threatening, let's say, other tenants. That is more tied to wide. Can you go back to that slide, Robel, please?
Sure.
Yeah, to excuse me. Yeah, I don't see it.
Yeah, nuisance or damaging the unit.
Okay, yes, damaging the unit or damaging common areas in the building, those kind of behaviors could be considered as nuisance in that specific case, but not, as you were mentioning, the person who asked the question. Yeah, for instance, if you were to call 311, if a neighbor were to call 311 because there is noise in an apartment, even if it's a recurrent issue, there is very little that enforcement can do in that respect. So that likely would not be an issue in housing court that's going to lead to an eviction.
How about I'm noticing a lot of smoking, right? Like, is that a nuisance, right? Like, if a tenant is a smoker and, you know, can they just be kicked out of their apartment because they are, and that's a nuisance to a tenant? I just wonder, like, you know, how does that work, right? Especially like these buildings are much older, they're not necessarily, you know, well insulated or well, you know, like smoke sealed, right? Like, wouldn't the lack of smoke seal be a landlord issue for not maintaining the apartments, for that nuisance not being an issue to another tenant? Like, I'm concerned about how that can be used, and I'd like more clarity on that.
Go ahead, Maria.
Or, yeah, or you guys have a testimony of a case like that?
Not for good cause eviction, but you know, I've seen in other type of situations in which, as you mentioned, you know, there's recurrent smoke in a unit that is affecting other units. So what tenants generally have done is they have approached the landlord to try to mediate and try to remediate the problem in the specific unit, because, as you said, it could be insulation, it could be you know, different issues, could be with the issues with the windows, issues with the doors, but specifically with good cause eviction, I wouldn't be able to give you the most accurate response. I don't know, Robel, if you have additional information in that respect.
Yeah, it does not specify it beyond what we have. It's probably intentionally vague, but those definitions are no different than what applies in our um, in other such kinds of apartments. Now, what I will add here is landlords also, mind you, have a lease agreement, and they spell out in the lease what is allowed and not allowed in the lease. Some apartments, for example, specify that smoking is not allowed, and if you are violating that, they may not say, "Oh, well, you're leaving. I'm gonna evict you because you smoked or you're a nuisance." They may just say you violated the lease term, which is even a greater reason to evict you. So yes, smoking can be if the landlord specifies it in the lease that it is not allowed. Just as well, pets as well. For example, not pets in the sense that um, you know your pet bark, but if they said pets are not allowed and you ended up getting a pet, um, they can evict you for violating lease term. And so the same thing applies here as well.
And is this strictly for rentals? In New York City is full of so many types of leases, right? So how does that qualify for condo and co-op owners? Or are we talking explicit rentals, and how does that, and how about in public housing, right? So just want to understand, every category of housing that we have in New York City, and how a nuisance could, be, just elaborated into something much bigger.
The public housing, I wouldn't say much beyond what I said earlier um, in terms of how more generous it is to tenants as far as overall eviction. Um, it has the most protection generally in terms of remediating a problem if it exists before the city resorts into evicting a tenant generally. Um, but we've been covering tonight the apartments that are covered by the good eviction law. Basically, these are market rate apartments that happen to be owned by a landlord who has more than 11 units statewide.
So that excludes co-ops and condos.
Yeah.
Yes,
It was
co-ops
Oh,
and
it is.
condos
Sorry.
are not are not included in this.
Understood. Thank you for that.
I will just go to the slide here where it says co-ops and condos are not covered by this law.
Copy. Thank you.
I have a question, or maybe a clarifying question, about the process. So I understand that, let's say, I know, I have someone, the landlord cannot evict you, the courts, actually.
would do
The courts evict you. So let's say that, this tenant gets, the landlord says X, Y, and Z. So actually help me to understand this process. The landlord tells the person, I plan to kick you out. I mean, I know they can't do it, but let's say they tell, you've violated the lease and I don't want you here anymore. Then does the tenant collect documents to try to prevent him or her from getting evicted, or does it go to court? Like, what is the process? Because I know you said the courts decide. I'm trying to figure out, like, where does the good cause eviction come in? Like, is it after the courts have said X, Y, and Z? Or should you have your documents ready and then try to thwart this? That's what I need to understand.
Gotcha. Okay. All right. So let's have a scenario where a landlord that you thought of yourself as market rate apartment, so you got into the apartment as a market rate tenant.
Okay.
And then after the law passes, you find out, oh, I am market rate apartment, but I am a good cause covered market rate apartment. And then you're like, okay, what does that mean? It means I cannot be getting rent increase that is above 10%. It must be at the 5% plus inflation rate. And if my landlord decides he's gonna go 11% increase this year because I don't know, let's say he has a lot of rent stabilized apartment in my building, and he's just gonna increase the rent on more on those that are not rent stabilized. Then you can say, hey, you're not gonna do that, and you let them know. And if they decided go ahead and charge you anyway, you don't pay it. Then the landlord is forced to take you to court for non-payment to get what he thinks or they think that they're owed from you. Now, what we have advised, if you notice here, is you continue to pay the rent that you had been paying all along, just not that unreasonable increase, that just not that over 10% rent he just put on you. Then, if the landlord takes you to court or he says, I'm going to evict her instead, I'm not even going to ask for the 11% increase since she's not paying, I'm going to evict her. Well, he's going to have to still take you to court. He has to say, the court would ask, why are you doing this? And you'd say, I gave her an increase, did not pay. And so since she's not paying the rent that I asked for, I don't want to keep her. Well, then you'd be able to say in the court, if the judge asks you, why didn't you do this? Then you can say, the increase that he demanded of me is over what the good cause eviction allows, one, and two, I did not refuse rent renewal. He just decided not to give it to me. I'd be happy to renew the lease, just not at the unreasonable amount. And then the judge will examine whether what even one thing I haven't said in this presentation is it is still up to the judge discretion. Sometimes they may even allow over 10% increase, unfortunately, but hopefully they won't is the hope, but it is up to the judge discretion. Hopefully the judge will say, Mr. Landlord, you are very wrong. And this is what the law says. Whatever reason you brought to justify to increase Rashida's rent above the 10% or the more than inflation rate is incorrect, and the case would be dismissed, or you would be given a reasonable amount, meaning he has to stick to the 8.79 rent we talked about earlier increase, but he can go up to that. Does that make sense?
Okay. No, it does. That does clarify things because I just needed to know. It seems as if the good cause eviction, I know it's meant to protect people, but as you mentioned, the judge still has the last word. And so let's say the landlord and the judge happen to be friends. I don't know. It could be that the judge is like, you know what, you need to move out. So if that does happen, I know these are kind of what ifs, but that's what we can play with right now. In a scenario like that, do you still have like a 30-day, and I guess that's up to the judge, right? Or is there like a law that says, okay, after you get that, you have 30 days or 60 days or 90 days?
Yeah, I mean, these things are not very complicated. And the laws are very clear. And if you don't go, particularly if you're going to this with a housing attorney, particularly, I have rarely, shouldn't say, but New York City's judges and courts overall are way more friendlier to the tenants' causes because the laws are written in such a way that it's the city's interest, city governments, the state government's interest that people remain in their houses. So I would be very surprised if it's cases of landlord and judge friendliness affects the court's judgment. in such a way because it's transparent. It is not, and it's, by the way, appealable too. I don't think it's the last word. If I correct me if I'm wrong, Maria, but landlord courts can also be appealed, correct?
I believe so, but with good cause eviction, I am not 100% sure.
Yeah, I think they are. They are.
So it can be appealed, but a marshal will physically remove you from your space.
Well,
And then-
while the court procedure continues, you still stay to get in your home until the court process is exhausted. But I don't think these cases go that far. I know we're going into the weeds, and I'm not a lawyer, I should say. Here, I shouldn't be giving any legal advice, but these things don't go that far. Usually, they're handled at first instance, and the laws. I know this law is relatively new, but the housing court processes are not that complicated per se. What they tend to have is a longer docket of cases where they have to go through them, and that can be a little lengthy. But yeah, go ahead, Maria. I'm sorry.
Yeah, just wanted to say that generally in eviction cases, there is, even when there is a notice, excuse me, when there is already, an eviction, that the judge has already ruled that there is an eviction to be executed, still the tenants have the opportunity to appeal and present an order to show cause in court that will kind of like reset the whole process to the beginning where the client can provide additional documentation and but yeah, as Robel was saying, I think that having legal counsel, legal advice, either through housing court answers or through any of the legal service providers that work with nonprofits in the area would be the best course of actions for tenants.
Thank you. I just,
One more question.
oh, no, for sure. I feel like we, even if this doesn't apply to us, we do want to ask the questions so that, for those to whom it applies, they have answers. So I'm gonna turn it over
Yeah.
to Jessica.
I'm still so stuck on the how vague like the nuisance thing is. So I know you guys had mentioned regarding like harassment, right? So I wanted to dig deeper on, say you live in a building, right? And for whatever reason, right, they don't like you, right? So now they're, harassing you, right? And now, like, can you then kind of report that someone, should be removed because they're harassing you in a place where you live, right? Like, what would you constitute like someone who's a nuisance because they are harassing other tenants in the building? And what could a process look like to evict them?
I mean, oftentimes these things are unfortunately and handled by law enforcement. The landlord-tenant harassment is much easier and straightforward as far as we're concerned in terms of harassment, but tenant against tenant harassment is vague, and you have to call if the harassment indeed is that bad. You do have to call the police, unfortunately. And landlords sometimes may not intervene even. We're talking about here overall the process, the trend is landlords don't do anything about it, and it's usually tenants have to look out for each other. for themselves, excuse me, not each other, for themselves. If they're being harassed by anybody in that building, the landlord may ignore it, and it is up to you really to look out for yourself.
Thank you.
Are there any other questions?
No.
So, do you have any questions for us?
No, I hope what I'll say is I hope this has been useful. And of course, happy to come anytime you need us to clarify any particular topic that my team covers particularly. I regret that what you had requested was not part of what you had requested was not something we specialize in. But I was always happy to put you in touch with people who can, and Chris attempted. I'm not sure how to which direction it went, but anytime you need assistance, we're here. Between Michael, myself, Maria, and Chris, be happy to help out with any tenant related issues.
No, thank you. And I'm sure with any, like the upcoming changes in governance, so to speak, in January, new concerns might arise. So we will definitely reach out to you if necessary. We still have the rest of the year ahead of us until June in terms of guest speakers. So if there's any topic that you cover and that we feel the community can benefit the community, we will definitely reach out. And we thank you for coming for this and presenting to us for this.
Pleasure.
Do you
all have a
slide
wonderful
with your
night.
information? Sorry, does he have a slide with his information and stuff?
Oh, no,
Like contact information and email, just so we can
Yeah.
close out with that.
You do have our email address. My email address is my last name, Teklab, TEKLEAB, then R, my first initial, at hpd.nyc.gov. And Maria's email address is, Donado, that is her last name, DONADO, and then her first initial M at hpd.nyc.gov. But we are, if you just keep on walking I know Artie was part of the
Yes.
setup team. Be happy to correspond to that. If you all are CC'd in there, happy to email you back and forth as well.
No, thank you.
Thank you.
Thank
You're
you.
welcome.
Thank you.
Thank you. Have a
And
wonderful
happy
night.
holidays.
You too.
Happy holidays.
Thank you.
Bye.
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 I'm going to do the roll call. I think sometimes people drop out, but they all fell out at once. I'm not sure if it was them getting picked out, but anyway, it doesn't matter. So, I will now do the roll call. Rashida? Here. Jessica? Here. Ingrid De Leon? Richard Perez?
Here.
Brittany Reynoso? And, Julie's. Anyway, so the next item on the agenda is the approval of committee minutes from Monday, November 24th, 2025.
Yeah.
Do I have a motion for anyone?
Motion to approve the minutes.
Yeah.
Okay, so the minutes have been approved. So we already had our presentation, and thank you.
Yeah, Maria's just
second. And Robel, thank you for that presentation and the Q&A session. As I mentioned, this is recorded, so people will have an opportunity to look back at it, which people actually do, like they tend to watch the recordings. So the next item on the agenda is the chair's report. And interestingly, the chair's report sort of dovetails with something that we voted on previously, TOPA.
Yeah.
And that was also going to be my unfinished business. So today's chair's report, I'll kind of shorten it. It's from the Bronx Times, I want to say. So I'm just going to shorten what I came across. Basically, it said, this is from December 19th. So Bronx-based affordable housing groups won a city council vote yesterday, so I'm assuming it was December 18th.
Yeah.
On the Community Opportunity to Purchase Act, which is COPA. So we've been looking at TOPA. This one is the community partnership COPA.
I did notice that. Yeah, thank you.
So I was like, okay, and it's a bill that gives nonprofits new leverage to buy distressed apartment buildings and keep them affordable. And then I'll just skip over. If signed into law by the Mayor Adams by the end of the year, it will come into effect in 2027. And I'll just read another line. So several organizations that aim to use COPA are based in the Bronx, which suffers the most out of all of the boroughs from the city's affordable housing crisis. And it said 8 out of the Bronx's 12 community districts are in the highest risk category and facing the greatest threats to affordable housing, according to the latest housing risk chart from the Association for Neighborhood and Housing Development. So the reason why I was like, okay, this is interesting because, and actually also the Northwest Bronx Community
And Clergy Coalition.
they were mentioning here, the guest speaker who came before, I've recognized Julie Cologne, was that Julie Cologne's advocated for COPA at a rally in front of City Hall alongside organizations from across the city. So that I was like, okay, I remember that. So the reason why I thought this was like a
Yeah,
nice,
yeah, transition, yeah.
exactly is because I brought up TOPA to the executive committee. And I know it might seem, since we voted twice, so we voted as one board and then we voted two board. And given that we have a new mayor-elect coming into office in January, what was recommended was that we wait because they're going to have given, and this is based off of other people's experience with bills and things like that, that it's going to be reintroduced with a new name and
Oh, wow,
so
okay.
this like that we should wait until after the transition
Yeah,
and then bring it up again in February.
Okay.
And in the interim, some things were brought to my attention about like some of the questions that came up. And these were like legitimate. I mean, not that anyone's other questions are legitimate, but they were like, if a person decides to sell a home to their, let's say I have a home and I want to sell to my niece or nephew, yeah, will I be prevented from doing that based off of this sort of
Right.
law? And I think that's, like this is meant to protect people,
only if they have tenants, right, so that, right.
But then that was someone's question, like, why then should I be denied that right to sell to a family
That's a good
member?
question.
And I was like, okay, that's good. And then another question, not a question, but someone who happened to come into like we didn't vote on it, but was privy to TOPA brought to my attention that I understand, like he seemed knowledgeable. So he said, I know it passed in Washington, DC. We know that Washington, DC is not a state. So we need to be mindful of like us being a state or places being states versus the District of Columbia. Like that is a different issue in that I wish I was more knowledgeable in this, but some of the protections that we are looking for might backfire in a sense. And I guess we kind of saw that with this good eviction clause, like it's meant to protect you, but then even though the judge might be lenient when it comes to tenants, it could also be that the judge is like, hey, you need to get out.
Right.
Yeah,
So there are these different things.
So even
Some-
that's
yeah.
in mind, at times is.
And it definitely a lot, it's so convoluted because it's just like, as much as we want everyone to be successful, right?
Exactly.
And I think Rebel did a really good job of just saying like, as long as the tenant is seeking housing, like that case continues to be open until they're housed.
Right.
But like, if us having a system of unhousing our own people and then complaining about homelessness
Right.
kind of like puts us in this redundancy loop where it's just
Yes.
like we are the problem there, like
Right.
it's just like not every cost of living is too high.
Right.
Everyone's everyone's can have a case of eviction, right?
Yeah,
So
right.
like being behind 90 days, that could happen to anybody, right? It's taking now on average people like what 9 months to get a new job if they get laid off.
Yeah.
Yeah.
So it's just like, what does that mean? You have to pick between food and housing.
Exactly.
That's, I don't know, it's just so confusing.
I think, and I think those are the conversations that wouldn't necessarily happen in a community board
Yeah.
meeting. They would erupt into arguments perhaps,
Mhm.
unless we have a guest speaker who can speak to these things. Like, well, we do have this in place. If you need food and I mean, I know you can say go to the friendly fridge,
Mhm.
but I'm just saying like.
Yeah, it's not the same.
It
It's
is not the same at all. And the thing is that I don't know how long it takes from you to apply for SNAP benefits
Mhm.
before you actually can get them.
Right.
And if it's more than 90 days,
Then what is do not.
then you know, we're like,
Mhm.
so for at least 90 days, say you lost your job, right?
Right.
And worse, even if you have a family, right?
Right.
Like, so say you lost your job. Okay, if you don't have savings, right? If you're a paycheck to paycheck person, right? You have to eat.
Yeah.
Right? So that means say you stop paying rent for 3 months. And then I guess the next question is that does it have to be 3 consecutive months, or is it like
Yeah.
on and off, like, you know, hey, you've missed a month in the last year. Like, I don't know what
Right.
the rules are, right? But somebody's gonna have to decide, like, am I paying rent, or am I eating, or am I feeding my family, or am I feeding myself this month?
Right.
Yes, they'll apply for SNAP, right? When do people decide when to apply for SNAP, right? Like, cause then I don't know if there's stipulations in SNAP about like, well, how bad is it? And do you deserve to eat and get food
Right.
through this program? Like, that's really confusing. That's really, really confusing.
No, and that is legitimate because I don't know I'm not sure exactly what the cutoff is, but I know in conversations just about cutoffs, what happens is that um you could be someone who is still like living paycheck to paycheck in a sense, but
Mhm.
maybe you're not considered like struggling.
Mhm.
So as in you don't really qualify for SNAP benefits, but it
Right.
could be that you'll only make $1 over.
Yes, yeah,
So
that's
it's that
ridiculous.
sort of
Yeah,
thing. It's
yeah.
like,
Mhm.
so that's when I kind of feel like,
Yeah, like how long do you have to fall before the
Exactly.
government gets involved? Or is it like you have to, you know, hit rock bottom
Exactly.
and then, you know, like hitting when the farther you are from like equilibrium, the harder it is to get back. So
Yeah.
it's just like it's really tough that like we don't help people, you know, when they're slipping. Like
right,
they have to slip and bust their head open, and then now we want to care about it. Like I don't like that that's how things work. You know, at least my impression of it is. So,
Right.
but again, not an expert in that, because, you know, like being blessed to not have experienced homelessness in my life or being in a house, but like we're going in that direction, right?
right.
With everything's getting more expensive.
Everything, yeah.
Yeah,
That's
so
true.
it's just like we have to control those things that don't need to get expensive right now.
Exactly. And even on that note, some of the protections don't necessarily protect everyone. I know we asked about co-ops and condos a lot because I feel like people assume that if you are in a co-op or a condo that you have it together. Like you're not ultra wealthy.
They're struggling.
but you-
Co-ops and condos are
exactly.
struggling too.
No, exactly. But I
Right,
feel like
mhm.
those protections don't exist, and you have to kind of
Yeah.
find, like, dig deep to find if there are any of these programs.
Yeah, and you're on your own.
So
So I mean that's why we're in this community board,
exactly.
right? To see what we can do.
Cause I know for sure when it comes to like benefits for like food or rent help, certain people won't even want to work just because if they make
Yeah.
a certain
Right, we stopped that. Yeah,
threshold
yeah.
is there, they'll lose their housing or the benefit to get the help to pay for the rent.
You shoot yourself in the foot.
So, yeah, so they prefer not to even get the work. Who knows? And it's unfortunate because you kind of put them in a bind. You want them to work and kind of provide for themselves, but now your threshold is so low that if they were to get like a job that pays them 22,000 an hour, whatever it is, they can't stay with that program, so they prefer not to.
Yeah.
And it's happened in where I worked, where a medical system's like, no, I can't take the extra.
The promotion, yeah.
And do it.
Yeah,
Why?
yeah.
Because of this.
It actually affects my housing, and now
You
it's
need
like
to work more hours. Well, no, I can't. You know, and then she kept the pushback, and that's how we found out. And we're like, I get it. You know,
Wow.
but it's like us, we're like, oh, come on, you should work more, but then now you lose your home or the programs to pay for that rent, unfortunately.
right.
So-
And then you can't justify, you know, the promotion would have to be would have to justify itself, you know, for your cost of living, your full picture 360 cost of living, which we don't do for
Right.
New Yorkers, right? So
Yes, it's tough. I mean, I know they're coming up with all these new buildings, which is that's another thing. With these lotteries, they're not really lotteries, right? Because
Yeah.
you sign up and technically you're chosen. And I've seen this with many people. I looked online, read articles. Then the landlord will come back and say, "Oh no, you don't qualify because your program's supposed to pay the whole thing." You're like, "Wait, but I've been paying a portion of it someplace else." No, but unfortunately for this, you can't. So that's how they defend that they try to put people of low income in their buildings, but in reality, that's all they have to show is that
mhm,
they try to put you in. They don't
Mhm.
technically have to.
It's like a good faith,
Right. So they
Yeah.
get this approval to put these nice beautiful buildings, but none of us, or and I say
right,
us,
it's not for
I say
current New
us.
Yorkers, right?
Right.
Which has come up as a, you know, as a challenge. Where it's just like, are you building new buildings for the people that need the housing that are already here? Or are you building new buildings to replace the people that are already here,
Mhm.
right? So,
Yeah. And I have a friend in the community board by Dykeman, right? And I'm not sure if you guys, if you have the opportunity to go through there, but they're putting high rises all over.
Mhm.
Yeah.
And he said the same thing, where there's been a lot of complaints because a lot of people from around that neighborhood apply, right? They want to get into these nicer buildings, and a few people were selected for this lottery, the HPD lottery, and then all of a sudden they'll get a letter saying, "Oh, you don't qualify." After they put in all the paperwork, but they're like, "Oh," because they'll go based on numbers. So that's something that I think
well, we could
was
talk about having those lottery conversations, right?
I think it's
Like,
important because even I know it's not as much in this Bronx area in our community board A, but
not
You'll be
yet,
surprised.
right?
Yeah.
Not yet.
Yeah.
not yet, right? Because in the next point is they'll eventually make their way this way, right? Because it's all about getting land. The older buildings, landlords are like, "Oh, I'll sell it and whatever,"
Yeah.
and they'll knock it down, put a huge building, and then
And that's where this TOPA, COPA, that's
Yes.
where it all makes sense. That's where
Right.
and it's happening faster than people can process it,
absolutely, yeah.
which is really, really tough.
Mhm.
So,
And especially for us because we blink and something up is something else is up. Like what's going on here? It's so
Mhm.
fast, right? So
You see a crane, that's
Yeah.
what I've been told, if you see a crane, you should just assume. Like,
Mhm.
it's
Oh,
too
yeah.
late.
by Van Cortlandt, you see that new building going up, right? So it's like
There, oh, but that's the school,
that's a school.
That is a
Yeah,
school.
that's
Oh, that's a school. There's no housing.
There is next to it. It's
Yeah.
different projects.
Exactly.
What's the building to? Oh wow.
There's a lot going on over there. You said that maybe not here, but I do get those emails that say like, oh,
Yeah, what's
that's
happening? Yeah,
the
foundation
demolition.
work, yeah,
Exactly.
the announcements. I mean, but even that's being threatened, right? With like, not like lawyers are lawyering. That's really it, and they're definitely trying to bypass community input when it
Yeah.
comes to what gets built in, in
community.
their neighborhoods.
We have to
So
be strong with it because it's easy for us to have like short-term memories of this. Like we'll fight, get upset for a little bit, and then kind of let it
yeah,
go.
yeah,
and then
there's a
they're the
bunch
ones
of
that
things
take-
you can be spending your time on.
Right.
I agree 100%. So, this was a great presentation. I'm glad we put it on
I
it.
did.
Thank
I
you.
think it was good because I learned a lot. I didn't know a lot of that. Really good.
So what do you want to do? So you did your chair's report.
Sorry, I was about to
Go ahead.
leave.
Oh, no.
My bad. Any new business?
No.
So then the next item after new business is adjournment. So if anyone would like to make a
You want a motion to adjourn, you'd say?
Motion to adjourn.
Second.
then I will officially
7:57.
and this recording will now stop.